the Bar Exam Toolbox podcast. Today we're talking about the civil procedure doctrine of discovery as part of our Listen and Learn series. Your Bar Exam Toolbox hosts are Allison Monahan and Lee Burgess, that's me. We are here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Allison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we love to hear from you. And with that, let's get started. Hi, and welcome back to the Listen and Learn series from the Bar Exam Toolbox podcast. Today, we are continuing on with another important civil procedure topic, discovery. We started discussing discovery in a previous episode where we addressed the scope of discovery and work product privilege. If you'd like a review of the basics of discovery, go back and listen to that episode now. It's a great building block for this one. As a quick refresher, in a civil lawsuit, discovery occurs before the trial begins as the attorneys prepare for trial. It is the process through which the parties exchange information with each other, especially about evidence and witnesses they may present at trial. But not everything is discoverable. Civil procedure provides a set of rules so each party knows what they must provide and what they do not have to provide to the opposing party. Now that we've reviewed the scope of discovery, let's take some time to discuss how discovery works, its process, and procedures. Since a good place to start is often the beginning, let's first take a look at Rule 26A, the rule about initial disclosures. Now, I'll admit, this is not the most gripping rule you will ever read, but I encourage you to pay attention. It is an important building block as you understand trial procedure and discovery rules. Okay, so what does Rule 26A say? Under Rule 26A, each party must provide certain initial disclosures to the opposing parties within 14 days after the Rule 26F meet and confer conference occurs. In case you missed it, these disclosures must be given. The opposing party is not required to request them first. The party has an obligation to produce them whether they are asked to or not. So, what are these mandatory initial disclosures? What information or evidence must be shared? Rule 26A delineates 4 categories. 1. Contact information of individuals likely to have discoverable information and the information they are likely to possess. 2. A copy or description of all documents, electronically stored information, and tangible things the party may use to support its claims and defenses, unless the evidence will be used solely for impeachment. 3. Computation of each category of damages claimed by the disclosing party. And 4. Any insurance agreement that may be liable to satisfy a judgment in the action. So, as a review, contact info of a witness, all evidence the parties may use in their case in chief, how much damages they plan to claim, and any relevant insurance coverage. Does this 4th category strike you as a bit odd? Well, the reason parties must disclose their insurers relevant to the case is because those insurers may be liable. That goes to who has to pay out in the end. So this is important information for the parties to know. In some cases, insurance companies may even be brought in as parties to the case. One important note on initial disclosures. If a party fails to provide the 4 required initial disclosures, that party is not allowed to use that witness or information in a motion, hearing, or trial unless the failure was substantially justified or harmless. The takeaway here? Disclose it or lose it. Okay, now that we've covered initial disclosures, let's move down the discovery timeline a bit and talk about depositions. Depositions occur after initial disclosures take place and as the parties are preparing for trial. They are essentially the examination of witnesses outside of court in preparation for trial. For that reason, many of the same trial rules and procedures are followed, including objections. But there are also rules specific to depositions. This seeks to ensure a fair and balanced process for both sides. The rule to remember is this. A party is permitted to conduct up to 10 depositions of any person or party, though only one each, so long as each deposition is 1. Limited to 1 day of no more than 7 hours, And 2, proper notice is given, which essentially means reasonable written notice. What is reasonable written notice, you might ask? Well, great question. I'm glad you asked. To be considered reasonable, the notice must state the time and place of the deposition and the deponent's name and address if known. If the name is unknown, the notice must provide a general description sufficient to identify the person or the particular class or group to which the person belongs. Note, too, that no subpoena is required to depose a party, and a party may be subject to sanctions for failing to appear at the deposition or for failing to provide the deponent for a deposition, even if the party is beyond the court's subpoena power. Okay, so up to 10 depositions, 1 deposition per person or party being deposed, and reasonable written notice. Oh, and depositions can only be 1 7-hour day. Now that you know the rules, we can talk about how the rules can be flexed. If a party wants to take more than 10 depositions, to depose someone a second time, or seek a deposition before the Rule 26F meet and confer conference, it can. But to do so, it just must first either reach a stipulation with the other party where they agree to do so or obtain leave of the court. One final note, sometimes a deposition needs to be taken from a non-human client. By non-human, I don't mean a dog. I mean an entity or a corporation. When that happens, the entity must designate a person to represent it for the deposition and may designate different people to testify on different topics. Before we move on to more substantive rules, let's be sure we feel confident in the framework by looking at a hypothetical together. This hypothetical was adapted from the February 2015 California Bar Exam. In March, while driving her car through her neighborhood, Diana struck and injured Phil, a pedestrian. In April, Phil filed a complaint against Diana, seeking damages for negligence and for physical injury. Diana filed an answer denying negligence. Both parties attended the Rule 26F meet and confer conference at the end of April. In early May, both parties engaged in initial disclosures. A week after the Rule 26F conference, Diana provided a comprehensive list of evidence and possible witnesses to Phil. Phil's witness list, provided 13 days after the Rule 26F conference, included himself, his spouse, Esther, who could testify as to how his life had been altered by the accident, his chiropractor, who had been treating him after the accident, and his boss, who could testify regarding his limitations at work after the accident. Along with his witness list and evidence, Phil provided a computation of damages totaling $750,000. In June, during discovery, Diana served Phil with written notice that she intended to depose him at the end of August. In mid-August, she served Phil with another notice that she was going to depose Laura, a physician who treated him after the accident. She discovered the existence of this physician from Phil's hospital medical records and bills that were provided to Diana in initial disclosures. Diana's notice of Laura's deposition was in the form of a written letter and arrived at Phil's attorney's office 2 days prior to the deposition date. Phil objected to both depositions, and neither Phil nor Laura attended the deposition. During pretrial hearings, both Phil and Diana argued that the other did not comply with initial disclosure requirements. Diana also objected to Phil's failure to produce himself and Laura for deposition. Phil argues that Diana did not comply with the notice requirements, and they therefore should not need to participate in depositions. How should the court rule? Let's take this one question at a time, reminding ourselves of the applicable rule and then working through how the court should apply that rule in this scenario. So first, did Phil and Diana comply with initial disclosure rules? Well, what do you think? Did each party provide the discovery required of them in the proper way? Well, let's review Rule 26A, which as a reminder covers initial disclosures. Remember, the first requirement is that each party provide initial disclosures within 14 days of the Rule 26F conference. Both Phil and Diana did that, so no issue there. Next, each party must produce 4 things. First, contact information of individuals likely to have discoverable information and the information they are likely to possess. The question states that Diana provided a comprehensive list of evidence and witnesses, so there is nothing indicating she violated this rule. What about Phil? Here is where you need to be paying close attention. The hypo does not explicitly say that Phil left out a witness or individual with information. But later on we learn that Diana discovered a potential witness, Dr. Laura, by looking through medical records. Phil did not disclose her as an individual likely to have discoverable information. Diana had to figure that out on her own. I think Diana has a good argument that Phil failed to disclose Dr. Laura. As the doctor who treated him at the hospital, she is an important part of this case and would definitely have relevant information that Diana has a right to know. I'll cut the next one off at the pass since nothing in the hypo points to an issue with the second requirement to share evidence and documents. In an exam, you will want to acknowledge that this requirement exists and then quickly move on by recognizing, like I've done here, that nothing indicates this as an issue. We do this so the grader knows you haven't overlooked one of the prongs while also spending as little time on it as possible. Moving on to the third requirement. As a review, each party is required to submit a computation of damages claimed, as Phil appears to have correctly done here. Again, there is no indication that he did not, and the hypo mentions his disclosure. Fourth and finally, each party must disclose any insurance agreement that may be liable to satisfy a judgment in the action. I think Diana is going to run into trouble on this one. Again, this one is a bit tricky and requires you to pay close attention. We don't know for sure that Diana has insurance that she did not disclose, but what we can say is that Diana did not disclose any insurance agreement, and it is certainly possible, even likely, that she carried at least car insurance that might cover her in this instance. Again, whether or not the insurance company is liable is something to be litigated. The rule of initial disclosures requires Diana to disclose her policies if they may be liable. In some cases, those parties can be joined to the suit and all questions of liability can be addressed in one go. We'll take efficiency where we can get it. Before we move on to the questions of depositions, let's quickly review where we stand. Both Diana and Phil have possible issues with the way they complied with initial disclosures. Phil could be liable for not disclosing Dr. Laura, and Diana may be liable for not disclosing her insurance policies. Moving along in the hypo to dispositions, did Diana comply with reasonable notice requirements, and should Phil have produced himself and Dr. Laura for deposition? To the question of reasonable notice, here is where you get to flex your legal argumentation muscles. Diana provided written notice, but was it reasonable? On one hand, you can certainly argue that receiving 2 days' notice, especially for a doctor who may not have a very flexible schedule, is not reasonable. On the other hand, Diana could argue that she would have filed the notice earlier if Phil had disclosed Dr. Laura's existence. I can see the judge giving Diana some grace here. The parties both likely could have worked together better and just set a later time for Dr. Laura's deposition, so the judge may order them to do that and push back the trial to allow them to do so. I don't think Phil has a good argument for not having shown up at his deposition. The notice was quite reasonable, and as the party to the case, he should have anticipated he would be called. Again, the parties can and should have come to a mutually agreeable date for the deposition, but I don't think Phil has much justification for skipping his deposition. Again, though, this is your chance to shine. Show the test graders that you see both sides, argue for the position you think is best, and show them that you've grasped how to argue for reasonableness. True lawyering. Okay, that was long, but I hope it helped you see how important these framework rules are and how failing to follow them can get your trial off to a really bad start, both for your strategy and in the eyes of the judge. Now that we've covered some important procedural rules, I want to bring you back to discoverable materials. As we reviewed in a previous CivPro episode, a party in a lawsuit may obtain discovery of all non-privileged information that is relevant to any party's claim or defense and proportional to the needs of the case. What we haven't yet mentioned, however, is that this discovery includes electronically stored information such as emails, text messages, digital files, and metadata. This makes sense, right? So much of our lives are digital. It only makes sense that much of our evidentiary footprint would be as well. Because electronic information doesn't operate identically to physical files, there are specific rules for electronically stored information, or ESI. The rule to remember is this: when a party reasonably anticipates litigation, it must take reasonable steps to preserve electronically stored information. For example, suspend its routine document retention and destruction policy, or institute a litigation hold. If they do not, they may be subject to sanctions for failure to preserve ESI. The court may sanction a party for failure to preserve ESI only if 1. The ESI should have been preserved, 2. The party failed to take reasonable steps to preserve it, and 3. the ESI cannot be replaced or restored through additional discovery. If that three-part test is satisfied, the court may A. Order measures no greater than necessary to cure any prejudice, or B. If the failure to preserve was intentional, 1. Presume that the lost info was unfavorable, 2. Instruct the jury that it may or must presume that the lost information was unfavorable, 3. Dismiss the action, or 4. Enter a default judgment against the party failing to preserve the ESI. Okay, we're again deeply in reasonableness territory here, so the skills you built arguing reasonableness earlier in this episode will serve you well as we analyze the next hypothetical. A recently successful businessman purchased 20 personalized suits from a local bespoke clothier. The businessman personally selected each detail. The suits, worth $5,000 apiece, were completed on April 1st, at which point the customer still owed half of the $100,000 contract price, which was payable in full 2 months later. On April 14th, on his way to work, all the buttons on his suit shattered. Annoyed, he turned around and went home to change into a new suit. To avoid any further embarrassment, he pulled on the buttons of each of the other suits before heading out the door. Each button shattered, and he was unable to wear any of them. When the businessman complained, the clothier told the customer, "The issue is with the button manufacturer. We did nothing wrong in designing the suit. Here's the contact information for the button manufacturer. They should reimburse you or send you some new buttons. If they say it was an issue with how we attached the buttons, we'll fix it." The businessman immediately contacted the button company and sent them his suits to examine. On April 30th, the button company provided the businessman with a written report on the condition of the buttons in the suit design, which stated that the buttons were fine but were improperly attached. They further reported that the design of the suit and stitching would cause any button to shatter in that way. On May 10th, the businessman sent the clothier the report with a note that said, "This is your problem. Until you give me 20 new suits with better design, you won't get another penny from me." The clothier immediately contacted an attorney and directed the attorney to prepare a draft complaint against the businessman for breach of contract. On June 10th, the clothier filed suit for breach of contract. The businessman's answer denied liability on the basis of alleged defective design and composition of the suits. During discovery and preparation for trial, the businessman has asked the court to impose sanctions for the clothier's failure to comply with the businessman's demand for electronically stored information, specifically, copies of all emails with component manufacturers concerning design and composition of the businessman's suits. The clothier destroyed all such emails on July 2nd, pursuant to their standard data and document destruction practice of destroying documents after 60 days of product delivery. Should the court sanction the clothier for the destruction of emails related to the case? Explain. Well, what do you think? Did the clothier act appropriately in following its normal document retention policy? Or should it have retained those documents? If so, should it be held liable? How should the court rule? Well, the clothier's actions may have seemed innocent. They didn't do anything different than they normally would have. But when faced with litigation, the point is they should have. Because the clothier anticipated litigation regarding its contract with the businessman, they filed the suit, no pun intended. They were wrong to destroy the emails related to the design and crafting of the businessman's 20 suits, even though they followed their normal document destruction policy. Remember, as we discussed in one of our earlier Civ Pro episodes, a party to a lawsuit may obtain discovery related to any non-privileged matter that is relevant to any party's claim or defense. This includes emails or other electronically stored information. And as we reviewed today, when a party reasonably anticipates a litigation, it must take reasonable steps to preserve electronically stored information. For example, suspend its routine document retention and destruction policy or institute a litigation hold. In this case, the businessman requested emails relevant to this case. The clothier would be responsible to turn these over during discovery, but he could not since the emails had been destroyed. Typically, spoliation of evidence, that is, destruction or alteration of evidence, is improper if the party who destroyed the evidence has noticed that the evidence is relevant to the litigation, or if they should have known it would be relevant. This is true even if the litigation hasn't yet commenced. In this case, the clothier had directed its attorney to draft a complaint weeks before destroying the ESI. Even if they weren't yet sure that the litigation would go forward, they had a duty to take reasonable steps to preserve the evidence, even changing their normal document destruction policy. In determining sanctions, the court also considers whether the ESI can be replaced or restored through additional discovery. In this case, it is possible that the court could issue subpoenas to the other parties on those emails to try and retrieve some of the destroyed ESI. It may or may not be possible here. If it isn't, the court may well order sanctions against the clothier. Sanctions are a tool the court can use to control the litigation process and ensure order. If the court chooses to order sanctions, it will determine whether or not the clothier acted intentionally in destroying the emails. There is indication that they did, in which case the court will consider the prejudice against the businessman in determining the level of sanctions that are appropriate. I know not all of you will be thrilled by the procedural rules. They certainly aren't the focus of Law and Order. But knowing these rules and being able to analyze them will not only make you a great test taker, but they will make you a great litigator or in-house counsel if that is your dream. As you master these rules, be sure to practice writing your way through lots of practice essays so you can get comfortable spotting and applying each rule before exam day. And with that, we're out of time. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it. And be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or Alison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.